Okay, ever get that feeling like you're wading through mud when you try to read some official rule or regulation?
Oh, yeah, absolutely. Eyes glaze over, the sentences just seem to get tangled up.
Right, like trying to untangle a really knotted up, I don't know, a phone charger cable or something.
Yeah, totally.
Well, that's kind of what we're doing today. We're untangling those knots, but in the world of law.
That's right.
We're talking about how laws, and specifically those big important ones, Acts of Parliament and all those rule books, how they actually get their meaning.
Exactly. And it's really interesting because the material you sent over, these excerpts from this text called Legal Method, it really digs deep into how these laws are written down and then how they're actually interpreted and used out there in the real world.
Yeah. And it's fascinating. It's not just about, dry legal definitions.
Right.
There's some unexpected stuff in there, some real challenges, even a bit of a history lesson about how these laws came to be and how we figure out what they actually mean.
Yeah, no, I thought that was really interesting too.
So by the time we're done with this deep dive, you should have a much clearer picture of how these statutes work, why we always need interpretation, and the different ways that's done. And the goal is, like always, those light bulb moments, but without giving you a total information overload.
Yeah, for sure.
All right, so let's jump in. I think one of the first things that really struck me when looking at this was this idea that at its core, making a law and then figuring out what it means is basically all about communication.
Totally. Yeah.
It's like lawmakers are trying to send a message.
Right.
Just like when you explain an idea to someone or write a letter.
Exactly. It is. Yeah. It's like you're trying to communicate something very specific.
And I think we all know, and probably have experienced this firsthand, that even a simple text message can be totally misunderstood.
Oh, yeah.
Language is a minefield.
Right.
There's always room for different shades of meaning, ambiguity, and when you then scale that up to the complexity of legal ideas and think about all the people who need to understand and follow those laws, you can see how things can get really messy really quickly.
Absolutely. And it's not just about the language itself being complex.
Right.
The source material highlights how important the constitutional side of things is.
Okay.
Specifically, this principle of legislative supremacy.
Right.
That Parliament gets to make the laws.
Yeah.
But the courts still have this really crucial role in figuring out the boundaries, even the limits of that supremacy. So it's not just about decoding words. It's about navigating this whole constitutional landscape, too.
Yeah, it's kind of like understanding the rules of the game, but then also knowing how the referee is going to apply those rules.
Right, exactly.
Okay, so we're on the same page about this communication idea.
Yeah.
But it also seems like not all laws are made for the same purpose, right? The source talks about different types of acts of parliament.
Yes, absolutely. There's this main distinction between public acts, the ones that change the general law for everybody, and then private or personal acts, which are way more specific, dealing with particular places or people.
Okay. Can you give us an example or two just to illustrate that difference a bit more?
Sure, yeah. So a personal act could be something like allowing a marriage between people who are related in a way that's normally not allowed under the law.
Okay.
A private act might be something a local council wants to get specific powers to manage a particular park in a certain way.
So these private acts are very targeted.
Very targeted, yes.
Does that then mean that the way we interpret a law that applies to everyone, a public act, is different from how we interpret those very specific private acts?
Usually, yeah. The interpretation tends to be very specific to that act itself.
Right.
Because private acts deal with these unique situations, a court's decision on what words mean in one private act won't necessarily create a binding precedent for interpreting similar words in another private act.
Okay, so it's very much on a case-by-case basis.
Yeah, exactly.
But the source does mention a possible exception to this.
What's interesting is, if a private act, even though it's focused on something specific, is meant to serve a wider public benefit,
Right.
not just some commercial interest, the courts might approach interpretation a little differently. The example they give is the Malvern Hills Act from way back in 1924.
Oh, okay.
It was a private act designed to preserve the Malvern Hills for public use.
And the issue there, if I remember correctly, was about this phrase, all lands common or waste, right?
Yeah, exactly.
What did that actually mean?
The big question was, did that mean all common and wastelands, excluding other types of land?
Okay.
Or did it mean all lands, including commons and wastes, with those being specifically mentioned just for emphasis?
Ah, okay.
Now, the court recognizing that this act was for public benefit, leaned towards the broader interpretation.
Right.
They figured the alternative would have led to this kind of strange outcome that Parliament probably didn't intend.
Yeah, makes sense.
So even with private legislation, the overall purpose can really shape how those words are understood.
Okay. So even when we're talking about very specific laws, that broader intention can still come into play.
Absolutely. Yeah.
All right. Let's shift gears a bit now and talk about precedent. You know, in law, previous decisions from courts usually carry a lot of weight.
Right.
So how does that work when we're trying to interpret statutes?
So this is where it gets really interesting.
Okay.
The source makes a really important distinction.
Okay.
Decisions about the meaning of ordinary everyday words that are used in a statute, they're not usually binding precedent.
Okay.
This is because the meaning of a common word is usually considered a question of fact that the court needs to determine in each specific case.
Right.
They actually quote Lord Reed in here saying, "The meaning of an ordinary word of the English language is not a question of law. The proper construction of a statute is a question of law."
Okay, so give me an example. If a law uses the word bicycle, a previous case that had to figure out what a bicycle was, that doesn't automatically dictate how a court in the future, dealing with a totally different law, would interpret the word bicycle.
Exactly.
Okay.
However, decisions about the construction of a statute, meaning how the words fit together, the legal effect of a specific phrase within that law, that can be binding precedent.
Okay.
Because that's considered a matter of law.
Right.
But there's this really important caveat, and this is where Sam and LJ comes in. He said, look, you can't just take the meaning of a word from one statute and automatically assume it's going to mean the same thing in a different one.
Right.
The primary job is always to figure out what the words mean within the specific act that you're looking at right now.
Okay, so basically each statute needs to be understood on its own terms,
Yeah.
while past cases can offer some guidance.
Absolutely, yeah.
So precedent in this area is more about the approach to interpretation rather than having these fixed meanings that are set in stone across every single law.
Exactly. So the decisions on one statute are really persuasive authority when you're looking at another one.
Okay.
They offer insights into how courts have dealt with similar problems in the past.
Okay, so it's about learning from past experiences.
Exactly.
Now, the source mentions this phrase, in pari materia. What does that actually mean?
So in pari materia literally means on the same subject matter.
Okay.
And when courts are dealing with statutes that are all about the same topic, they might look at how certain words or phrases have been interpreted in those related statutes.
Right.
But the courts are usually pretty strict when deciding whether statutes are truly in pari materia.
So just because two laws touch on a broadly similar area, that doesn't mean past interpretations are automatically going to be carried over.
Yeah, that's generally the approach when you're talking about the statutes themselves. But the source does point out that there's a slightly less strict approach when it comes to statutory instruments.
Okay.
Those are things like regulations or rules that are made under an act. There's this case, the Newcastle-upon-Tyne Justices case, that illustrated how a statutory instrument, even if it wasn't made under the specific act that the court's looking at, can be used to help understand an earlier statute,
Okay.
as long as it clarifies some procedural point.
So they're sort of looking at the bigger picture, the wider legal toolkit to try and make sense of the law.
Yeah, exactly. That's a good way to put it.
Okay, that's really interesting. Now, I want to switch gears completely and talk about how these laws actually get written in the first place, because the source goes into the history and the modern practices of statutory drafting, and it turns out it hasn't always been a simple process.
Oh, not at all. It's actually kind of fascinating. They point out that the very beginnings of Parliament are still debated.
Right.
But it definitely started as more of a forum for discussion and debate. And making laws was mainly the responsibility of the king and his advisors.
Right.
And get this, statutes used to be written in Latin and Norman French. It wasn't until the 15th century that this practice of drafting bills in the same form as the final statute became common.
Okay. But even then, things weren't exactly smooth sailing, were they? The source mentions how people, even back then, were complaining about laws not being clear enough.
Yeah, totally. There's this great observation from a scholar named Allen, and he describes how early statutes were either super short and often obscure,
Okay.
or they went to the other extreme and became so wordy that the law got buried under this mountain of text. It seems like the struggle for clear legal writing is age-old.
It's funny how some things never change, right?
All right.
We even have literary heavyweights like Alexander Pope and Jonathan Swift weighing in on the dangers of using too many words.
Yeah, and Swift's idea in Gulliver's Travels about limiting laws to the number of letters in their alphabet and forbidding any interpretation.
That's taking it to another level.
Yeah, a bit radical.
But it does kind of highlight this ongoing difficulty of making laws both precise and easy to understand.
Absolutely. And then the source kind of shifts to a more modern perspective, noting that specialized legislative drafting is actually a fairly recent thing in England. It didn't really take off until the late 19th century when the Office of the Parliamentary Council was created.
Okay, so that was a big turning point. What's the Office of the Parliamentary Council? What do they actually do?
They're basically these full-time specialist lawyers whose main job is to draft government bills.
Okay.
Before that, drafting was often done by lawyers within government departments or even in private practice. But appointing Henry Thring in 1869 was a huge step because it recognized that legislative drafting needed specific skills and expertise.
Right. It's a craft in itself.
It really is.
Yeah.
And the thinking now is that this specialization isn't just a good idea, it's absolutely essential for creating good laws.
Okay. So walk me through this process. The government wants to introduce a new law.
Okay.
How does it work with the Parliamentary Council involved?
So it all starts with government departments. They come up with the policies, they figure out what they want to do,
Okay.
and then they send these detailed drafting instructions to the Parliamentary Council.
Okay.
These instructions, they lay out the purpose, the background of the law, how it affects existing laws. But it's not actually a draft of the bill itself.
Got it.
But it might refer to similar things in existing laws.
Okay. And then the Parliamentary Council takes over from there.
Basically, yeah. So a senior counsel is assigned to the bill, and they usually work with the junior counsel. The senior counsel, they're sometimes called the draftsman. They're responsible for the actual wording of the bill.
All right.
And that involves not just writing, but also clarifying, refining the policy details, working with government lawyers and administrators,
Okay.
and also figuring out the best structure for the law.
So there's a lot of back and forth.
Oh, yeah, a lot of collaboration.
Roughly how many drafts do these bills typically go through?
It can be a lot. For a big, important bill, it could take 9 months, maybe even longer. And it could go through 10 or more drafts. As it's reviewed, revised, people give feedback from different government departments.
Okay.
And once they think it's pretty much final, it goes to a committee of ministers for their final approval.
All right.
Then it's ready to go to Parliament.
But even then, the wording isn't set in stone, right?
Absolutely not.
You often hear about amendments being made.
Yeah, bills can be amended at various stages in both houses of Parliament.
Okay.
So government amendments are drafted by the original Parliamentary Council,
Right.
but based on instructions from the government. Amendments that other members or outside groups propose,
Okay.
they're often not as well drafted.
Yeah.
And if the government likes the idea, but not the wording,
Okay.
they'll usually ask whoever proposed it to withdraw it and promise to introduce a properly drafted government amendment later on.
Makes sense.
And even if a tricky amendment gets passed against the government's wishes, the Parliamentary Council will have to fix any drafting issues that come up.
It's almost like a constant editing process, right?
Yeah, kind of.
Now, there's this interesting bit in the source about an experiment with using private sector drafters for the Finance Act 1996.
Oh, yeah.
And it sounds like that wasn't really a success.
It wasn't. It turned out that using those private drafters cost way more
Okay.
than the Parliamentary Council would have charged for a lot more work.
Okay.
They didn't repeat the experiment, which kind of suggests that the specialized expertise you get from the Office of the Parliamentary Council,
Yeah.
it's both valuable and cost-effective.
So you get what you pay for, basically.
Mm-hmm.
So what are the main principles that guide these Parliamentary Council when they're drafting? What are they trying to achieve?
Well, a former Parliamentary Council, Kent, said there are two main goals. First, making sure the bill is legally sound and accurately reflects the policy they're trying to put into law.
Okay.
And second, making the bill as understandable as possible for both Parliament and the public. And he made this really insightful distinction between clarity, unambiguity, meaning it's precise for legal experts,
Okay.
and clarity, intelligibility, where it's understandable to a wider audience.
Okay, so two different types of clarity.
Exactly. And this is the tightrope they have to walk.
Yeah, because it's one thing for lawyers to understand the precise meaning, But if ordinary people who have to live by these laws can't understand them, that's a recipe for disaster.
Oh, for sure.
It brings us back to that feeling of wading through mud.
Absolutely. And Sir John Rolland actually joked once that the intelligibility of a bill is in an inverse proportion to its chance of being right,
Okay.
highlighting this tension between simplicity and legal accuracy.
Right.
And the drafters also have to be mindful that lawyers are always going to try to find different interpretations, even in parts that seem perfectly clear. Stephen Jay said it best. The aim is to achieve a level of precision which someone deliberately trying to misunderstand the law cannot do so successfully.
So they're trying to outsmart the lawyers, in a way.
In a way, yes.
Yeah.
Anticipating potential misinterpretations.
Now, the source mentions this quote from Thring, and it's a bit cynical. He said that bills are made to pass as razors are made to sell. What does that mean?
It's cynical, but maybe a bit realistic, too.
Okay.
He's saying, just like you need to sell razors before people can actually use them to shave,
Right.
bills need to pass through Parliament before they can actually become law and have any effect in the real world.
Okay.
And Engel points out that drafters face these constraints.
Okay.
Statutes are legal documents. They need to be precise.
Yeah.
They don't have unlimited time.
Hmm.
And sometimes you can't just completely redesign a bill structure, even if it's a mess of amendments.
Right.
So it's not just about perfect language.
It's about politics, practicality, and getting things done.
Exactly.
Now, let's talk about some of the newer things in drafting. The source mentions publishing draft bills for public consultation.
Yeah,
That sounds like a good idea.
it is. And
Yeah.
it's a more recent thing. It's all about getting more eyes on the law before it's formally introduced to Parliament. The idea is to improve quality and make it more accessible.
Okay.
They give the example of the Draft Corners Bill from 2006. But they also point out that just putting explanatory notes directly into the bill didn't really lead to a breakthrough in plain language drafting like some people had hoped.
There's an ongoing process.
Definitely.
And then there's this massive project, the Tax Law Rewrite Project.
Oh, yeah.
What was that all about?
That was a huge effort to take existing tax law and rewrite it in a way that was more user-friendly, easier to understand, but without losing any of the legal accuracy.
Okay.
Because they recognize that some areas of law are just naturally complex,
Right.
but the way they're written can make a big difference.
Yeah, absolutely. So it's a constant balancing act, right?
Right.
You need legal precision, but also clarity and intelligibility.
Yep.
So the law is written. Now, the really important part, the interpretation. And the source talks about this idea of relying on plain meaning, but it seems like it's not as straightforward as it might sound.
Not at all. The idea that you could just look up the words in a dictionary and get a definitive answer, that's just not how it works. The problem is that lots of words have multiple meanings,
Okay.
and you can only really figure out the intended meaning by considering the context.
So words aren't always as clear-cut as they seem.
Right. It's not that simple.
And the source brings up this case, Bourne v. Norwich Crematorium, as an example of this.
Yes, it's a classic case that really highlights how words can have different meanings depending on how they're used.
Right.
So it's all about looking beyond the surface.
The source also mentions this case, our Guy v. Newcastle City Council. That was a really interesting one, especially in the context of cremation law.
Oh, yeah. That one really shows how context matters.
Mm-hmm.
It involved a Hindu man who wanted his body cremated according to his beliefs, which required sunlight to directly hit the body during the cremation. Okay, the local council said that cremation laws only allowed cremations inside a building. And a previous case had defined a building as having walls and a roof made of brick or stone.
Right.
But the open-air structure used for traditional Hindu cremations in India, that didn't fit that definition.
So a very literal interpretation of the law would have actually prevented him from having a cremation according to his religious beliefs.
Exactly.
But what happened?
Well, the Court of Appeal, in that Guy case, they took a different approach.
Okay.
They looked at the purpose of cremation laws and they considered the religious context.
Right.
So in this case, the meaning of the word building was interpreted differently because of the specific circumstances
Yeah.
and the overall aim of the law.
Okay.
So it's not just about what the word says. It's about understanding why that law was created in the first place.
So this simple literalism approach, just looking at the dictionary definition, that's pretty much a thing of the past, right?
Yeah, for the most part. But the source does say that it's still important to understand it.
Okay. Why?
For two reasons. First, by seeing the limitations of just taking words at face value, we can understand why the modern approaches have evolved the way they have.
Okay.
And second, even though it's less common now, some judges might still rely on a very literal interpretation in certain cases.
Okay.
So it's good to be able to recognize when that's happening and understand why.
Right, so it's still out there.
Yeah, it's part of the history.
And it seems like this tension between sticking to the words and considering the context is always going to be there, right?
Absolutely. It's a constant balancing act.
Okay, let's move on to the mischief rule. That sounds intriguing.
Right, it does sound a bit dramatic.
Like something out of a detective novel.
Yeah, it does. But it's actually a legal principle that comes from a very old case, Hayden's case, from the 16th century. And it takes a more purposive approach. So instead of just obsessing over the words themselves, it asks these questions. What was the law like before this statute was enacted? What was the problem, the mischief that this statute was trying to fix? What solution did Parliament want to create?
Right.
And the court's job is to interpret the statute in a way that gets rid of the problem and puts that solution into action.
Okay. So it's like being a detective, right? You're looking for clues about why the law was made in the first place.
Exactly. You're trying to understand the intention behind it.
Now, the source gives an example of a boundary dispute case.
Oh, right.
How would the mischief rule apply there?
So in that case, there was a redrawing of local authority boundaries, and the question was about compensation for those affected by the changes.
Okay.
A court using the mischief rule would have looked at the situation before the new law, figured out any unfairness or problems the law was meant to address,
Right.
and then interpreted the specific parts about compensation in a way that aligned with that purpose.
So again, looking beyond the literal words to consider the actual problem the law was designed to solve.
Exactly.
Now, the source says this mischief rule has kind of evolved into what's called the purposive approach. And that's how we mostly interpret statutes today.
That's right.
So how are they different?
The purposive approach takes the core idea of the mischief rule, looking at the aim,
Right.
and expands it. Modern judges are much more willing to accept that the purpose behind the words is a crucial part of the context.
Okay.
There's actually a quote in here from Lord Diplock, and he observed a clear trend in the House of Lords moving away from just looking at the literal words and towards this more purposive understanding.
So it's about understanding why a law was made, not just what the words say.
Exactly.
So what are the key differences between this mischief rule and this more modern purposive approach?
Well, the source highlights a few things. First, the mischief rule was traditionally used when there was a gap in the existing common law, whereas the purposive approach is used regardless of whether the area was covered by common law or statute.
Right.
Second, and this is maybe more important, purposivism is seen as part of this broader modern emphasis on context.
Okay.
It's kind of an evolution from literalism,
Okay.
while the mischief rule actually predates literalism.
Okay.
Third, Lord Diplock suggested that originally the mischief rule tried to keep the court's inquiry within the act itself,
Okay.
whereas purposivism allows you to look at extrinsic materials, stuff outside the act,
Right.
even potentially Hansard, which is the official record of what's said in Parliament.
Okay.
So purposivism gives you a wider lens.
Okay. So you can look at the bigger picture.
Exactly.
Now, the source gives a really interesting example of this purposive approach in action in a criminal case.
Oh, yeah.
RV Pig. What happened there?
So in this case, there was a conviction for rape.
Okay.
And there was a technicality in how the jury announced their verdict.
Uh-huh.
The foreman, he didn't specifically say how many jurors had disagreed, which was a requirement under the Juries Act.
Okay.
But the House of Lords, taking a purposive approach, said that the important thing, the point of that requirement, was to know that it was a valid majority verdict.
Right.
And it was pretty obvious that if 10 agreed, then 2 disagreed.
Okay.
So they prioritized the purpose, ensuring a valid verdict, over a super strict reading of a procedural rule.
So they looked at the substance, not just the form.
Exactly.
But doesn't this raise some constitutional questions? Because if courts are looking at the purpose and not just the words,
Yeah.
are they not kind of making law instead of just interpreting it?
Yeah, that's a valid point. And the source acknowledges that some people argue that the purposive approach gives too much power to the courts.
Right.
Like they're reading things into the law that aren't really there.
Right.
But the counter-argument is that Parliament and the courts are actually partners.
Okay.
They both have a role to play. The courts make sure that the law works effectively in practice.
Okay.
They even quote May LJ here, talking about this functional partnership.
So it's a balancing act. You have to respect what the law says, but also make sure it's serving its purpose in a modern context.
Exactly.
But even if we accept this purposive approach, how do courts actually figure out the purpose of a statute?
Right, that's the tricky part. Identifying the purpose can be a challenge.
Yeah.
Traditionally, the view was that the words themselves should be enough to figure out what Parliament meant.
Okay.
They even quote Lord Tyndall CJ from the Sussex peerage case, where he basically says, if the words are clear and unambiguous, then that's the end of it.
But what happens when the words aren't clear? What do the courts do then?
That's when things get interesting. The source talks about this ongoing debate about whether laws should actually include a statement of purpose.
Okay.
Some people argue that this would make things much clearer for everyone.
Yeah.
But the drafters themselves are often not so keen on the idea.
Why not?
They worry that purpose statements might oversimplify things or become just political slogans.
Oh.
The Renton Committee, they like the idea in principle, but they said purpose clauses should be carefully drafted.
Okay.
But even with all this discussion, these clauses haven't become that common in English law.
Okay.
Although there are some examples, like the Courts and Legal Services Act of 1990.
So figuring out purpose, it's still a bit of a gray area.
Yeah, definitely.